Right, that's up. Okay, so you have actually all been exposed to this, or these vessels. That's a horrible echo, because you had to do it in equity. A lot of these things, the remedial stuff and the institutional stuff, they are actually things that Tina would have talked about in regards to this. And so bear in mind that while you know probably what these terms mean, all we're doing as part of this process is to clarify some of those things and to go into some of the rules and sub-rules. And like resulting trusts, my personal note in regards to the textbooks, they are explained and structured in quite different ways as well. And so from your perspective, and this is a little bit of pragmatic thinking on my part, I care about how you guys can answer your exams. I care about the ability for you guys to translate a lot of this text into real concrete advice that you're giving to your clients and to advise them in those particular scenarios, and to hopefully take that information onwards in your professional career. Okay, which is why I've deliberately split this lecture up into these two halves, because constructive trusts operate differently from resulting trusts. They just are. They're a fundamentally, functionally different thing. They, I guess, do have some similarities in that they're trusts by operation of law, and that they need a court to actually declare them. And this is true of all equitable remedies anyway. All equitable remedies are discretionary. They all require the court to intervene. They're different and distinct from common law remedies in things like contract, where you can sort things out yourself. Constructive trusts don't really operate with intention, or at least not intention as we think of it in terms of discretionary trusts. It's not really their point or their purpose. They arise in situations in really two broad categories. They either flow from what we call unconscionable situations, or from what we describe as unjust enrichment. And these principles I'm going to talk about a little later today, because this varies a little bit from the UK and quite a lot from the other common law jurisdictions, and in particular the US. In Australia, this is the bastion country of unconscionableness being the basis for constructive trusts. And there's a great deal of reluctance to try and create them from unjust enrichment. Okay, and I'm going to go and talk about this case, Machinsky and Dodds. First thing to note about Machinsky and Dodds is that it is actually to do with the material we're going to be doing next week or a fortnight's time, which is the remedial classifications of constructive trusts. That was actually what that case was about. But Justice Dean did a very, very good job of sort of mapping out this area. Now, this judgment's quite long, and so I have gone through and paraphrased this, but just as a bit of background, it involved a slightly older German lady and a younger Australian man, and they had an arrangement for that she would stump up some money for a property, and he would help build like an art studio, and they would run that as a business together. And the fact that that sounds slightly business-like and slightly contractual in nature is a relevant series of points for the purpose of this case. Because like all of these scenarios, by the time it reaches one of the higher courts, the relationship is broken down. The parties want to go their own ways. And they're just arguing about who gets what. This is a recurring theme in trust law because trusts, as we're aware, fundamentally are about property. You only actually go to court where there is property, and you need to find who gets it, who gets the beneficial and or the legal interests. Okay, so I'm going to go through and essentially read from the judgment and give some commentary in regards to this. I hope you don't mind my speaking voice. I apologise if it's a bit bland. His Honour Justice Dean. By the time of completion of the purchase of the Picton land in the names of Mrs. Machinsky and Mr. Dodds as tenants in common, the overall arrangement between them was plain enough. Mrs. Machinsky would pay the whole of the purchase price, and together they would develop and use the land. They would purchase and erect a kit home in which they would live together. They would renovate the old cottage on the land so that it could be used as an arts and crafts business to be run by Mrs. Machinsky. They would subdivide the land and sell part of it. Mrs. Machinsky's main financial contribution was to be, and was, made when she paid the purchase price of the land and the associated costs. Mr. Dodds's financial contribution was intended to be made subsequently. He was, and as he tended by himself in evidence, to put the time, the efforts, the funds as necessary to develop the property up. In particular, he was supposed to pay for the proposed kit home and repay the mortgage arranged to be taken out in the parties' joint names to finance the project beyond. It was the basis of that overall arrangement that Mrs. Machinsky's solicitor advised her the property should be purchased in the names of herself and Mr. Dodds as tenants in common in equal shares. According again to Mr. Dodds, he notes that if it is placed in Mrs. Machinsky's name only, it would be unfair to Mr. Dodds to have him probably put in excess of $20,000 into the property over a short period of time. Now, they were living in a de facto relationship, and this broke down. And late in 1978, the parties separated. When this joint project was abandoned, the parties were left as equal legal owners of the project property, again, towards the overall cost in which Mr. Machinsky had contributed 10/11ths, about $25,000. And Mr. Dodds had contributed about the remaining 1/11th, about $2,500. I appreciate that was quite a lot of money back in the late 70s. That's a good chunk of your annual wage. There was no express or implied agreement, arrangement, or understanding between the parties that they should hold their legal interests upon trust for themselves in shares corresponding to their respective contribution. What is Justice Dean talking about there? A resulting trust, a purchase money's resulting trust. There's no evidence. In fact, it continues, quite to the contrary. The evidence leads inexorably to the conclusion that it was their shared intention, that is, from the time of the purchase, that each should have a full 1/2 beneficial as well as legal interest in that property. There was also no suggestion at all of any express contract, and no real foundation for the court to imply one. Now, His Honour continued to note that in these circumstances, there is no occasion for recourse for the presumption of the law of equity that when two or more persons advance the purchase price of property in different shares, the person or person to whom the legal title is transferred holds the property upon resulting trust in favour of those who provided the purchase price in the shares in which they provided it. So there Justice Dean is clearly saying in these circumstances, it's not going to be resulting trust. The parties in no way, shape or form intended that. They had their own system in place. Even in such a case, however, this presumption operates by reference to the presumed intention of the party whose contribution exceeds his or her proportionate share. It cannot prevail over the actual intention of that party as established by the overall evidence, including the evidence of the party's respective contributions. It follows then that no relief is available to Mrs. Machinsky on the grounds of breach of express or implied agreement, in other words, contract, or of express or implied trust. It was, however, submitted by their solicitor, Mrs. Machinsky's solicitor, that she was entitled to a declaration of constructive trust based on some broad notions of fairness and unjust enrichment. Those are the magic words, so to speak, to invoke the court's equitable jurisdiction. His Honour continues to then describe and talk about this distinction in constructive trusts between the remedy or remedial trusts and the institution or the institutional types of trusts. This, as he just referred to as this perceived dichotomy between these two catchwords, has, however, largely been the consequence of a lack of definition. In a broad sense, the constructive trust is both an institution and a remedy in the law of equity. As a remedy, it can only properly be understood in the context of the history and the persisting distinctness of the principles of equity that enlighten and control the common law. The use or trust of equity, by that use is the old word for trust. The old, if you go back 300 or 400 years, they didn't use the word trust. So if you do get some old cases, they'll have that term. So the use or trust in equity, like equity itself, is essentially remedial in its origins. That means its whole purpose is to be remedial. In its basic form, it was imposed as a personal obligation attached to property to enforce the equitable principle that a legal owner should not be permitted to use her or his common law rights as owner to abuse or subvert the intention which underlay the acquisition and possession of those rights. This is consistent with the traditional concern of equity with substance rather than form. In time, the relationships in which the trust was recognized and enforced to protect the actual or presumed intention had become standardized and were accepted into things like conveyancing practice in regards to settlements and property law as the equitable institutions of the express trust and the implied, and here he's thinking resulting trusts. In other words, over time, those rules became clearer, and we mapped out rules to do with resulting trusts. Now, like the counterparts of express and resulting trusts, the constructive trust also developed as a remedial relationship superimposed upon common law rights by order of the Chancery Court. It differs from those other forms of trust, however, and these are important words, in that it arises regardless of intention. So the constructive trust shares, however, some of the institutionalized features of the express and resulting trusts. It demands the staple ingredients of those trusts: subject matter, trustee, beneficiary, or, again, conceivably, purpose, and personal obligation attached to that property. In other words, it has trustees and they have duties. Viewed in its modern context, the constructive trust can properly be described as a remedial institution which equity imposes regardless of the actual or presumed agreement or intention to preclude the retention or assertion of beneficial ownerships of property to the extent that such retention, or assertion would be contrary to equitable principles. So they're saying, what he's saying there is that the whole purpose of this area is essentially to be the catch-all. Constructive trusts are designed to be this broad institution where things have happened and there's some of those two equitable principles that have arisen, either unconscionableness or unjust enrichment that have arisen, and the court needs to find some result for things that slip between the cracks. Because if we think about equity as a series of principles and rules, the whole purpose of equity is to resolve defects in the common law. And in many ways, you can look at constructive trusts as being the device that remedies defects in the other areas of trust law. Now, he does continue to then talk about how these things come about. And so he says, quite rightly, the principal operation, in other words, the most common situation, of the constructive trust in the law of this country has been in the area of breach of fiduciary duty. And once the predominantly remedial character of constructive trust is accepted, there's no reason to deny the availability of it in any case where some principle of the law or equity calls for the imposition upon the legal owner of property. And here he's talking about this shift away, this divergence from the UK and certainly the US and Australia, because we don't like using the term unjust enrichment. In fact, this is probably the single most clear expressed judgment. It may well be that the development of the law of this country on a case-by-case basis will eventually lead to the identification of some overall concept of unjust enrichment as an established principle, constituting the basis of decision of past and future cases. But the most that can be said at the present time is that unjust enrichment is a term commonly used to identify the notion of a variety of distinct categories of case in which the law has recognised an obligation on the part of the defendant to account for a benefit derived at the expense of the plaintiff. And therefore, it becomes necessary to consider whether there is any narrower and more specific bases on which, independent of the actual intention of the parties, Mrs. Machinsky can claim to be entitled to relief by way of constructive trust on the particular circumstances of this present case. Okay, now he starts to use some analogies from other areas of law. In particular, he's thinking about joint ventures and partnerships, because that was kind of what this was. It could characterize this arrangement. You appreciate that the Family Law Act itself was quite new at this stage. And so these cases have been taken under the causes of action in equity rather than under the Family Law Act. Both common law and equity recognise that where money or other property is paid or applied on the basis of some consensual joint relationship or endeavour which fails without attributable blame, it will often be inappropriate to simply draw a line, leaving assets and liabilities to owned and borne according to where they may prima facie lie, as a matter of law at the time of the failure. Where there are some express or implied contractual provisions specifically dealing with the consequence of failure of the joint venture or endeavour, they will ordinarily be applied in law and equity to regulate the rights and duties of the parties between themselves, and the prima facie legal position will ordinarily prevail. Where there are no contractual provisions, or the only provisions didn't really align with the contingency of premature failure of the enterprise, other rules or principles can be called into play. If the relevant relationship is merely contractual and the contract has been frustrated, the present tendency of the common law is that contributions made should be refunded, at least if there has been a complete failure of consideration of performance. The circumstances of this present case provide the necessary context for the operation of a general unconscionable principle of the law of equity. And here, Justice Dean is talking about this doctrine of unconscionably retaining or holding some benefit. Mr. Dodds is left, if we left things as they lay, as a half owner of a property in circumstances to which the parties did not think would have happened, and in which it was not specifically intended or specifically provided that Mr. Dodds should enjoy a benefit at Mrs. Machensky's expense. In these circumstances, the operation of the relevant principle is to preclude Mr. Dodds from asserting or retaining against Mrs. Machensky his one-half ownership of the property to the extent it would be unconscionable for him to do so. That's at paragraph 15. I'll read that thing again. In these particular circumstances, it would be unconscionable for Mr. Dodds to retain half of that property. Now, if the venture between Machensky and Dodds had been merely a commercial one involving the purchase, development, partial realization, and use of this Picton land, there'd be little room for argument about the appropriate characterization. You wouldn't need to use it. You just use contract law and those principles to work it out. If no more than the commercial relationship had been involved, Mr. Dodds' conduct in seeking to catch and retain the unfair advantage by asserting his legal entitlement of one-half interest without assenting to any adjustment to compensate Mrs. Machensky for the unintended gross disproportion between their respective contribution would plainly be unconscionable for the purposes of the relevant principle of equity. Indeed, if the relationship between the parties had been merely a commercial one, such conduct on the part of Mr. Dodds would be the very type that the relevant principle exists to preclude. In other words, if this was a commercial situation, and for whatever reason the contract had failed, it was somehow defective, you'd use estoppel. There'd be a rule in equity that would prevent somebody from withholding a benefit unconscionably. This is just unusual, and it's a mix and match between some commercial things and some private things. There was intention for the parties to do things in a certain way, and that's failed. They didn't really think about what was going to happen next. And it seems strange, again to Justice Dean here, that if this was a commercial arrangement, we would already have these rules set up. Whereas here, both sides are a little bit confused about what's going to happen, hence the reason it goes to the High Court. It follows that equity requires the rights and obligations of the parties to be adjusted to compensate for the disproportion between their contributions to the purchase and improvement of the Picton property. There remains the question whether there should be a declaration that the Picton property is held by the parties upon constructive trust. In my view, there should. That property was acquired in pursuance of the consensual arrangement between the parties to be held and developed in accord with that arrangement. The contributions which each party is entitled to have repaid to him or to her were made for or in connection with its purchase and development. The collapse of the commercial venture and the failure of the personal relationship jointly combined to lead to a situation in which each party is entitled to insist upon realization of the asset, repayment of his or her contribution, and distribution of the surplus. In these circumstances, the appropriate order is to give effect to the rights and obligations of the parties. It's an order declaring the Picton property to be held by them upon constructive trust, lest the legitimate claims of third parties be adversely affected. This constructive trust should be imposed only, this is the last line, I swear. This constructive trust should be imposed only from the date of publication by reasons for judgment of this court. Okay. There's a lot of things to unpack there. But what he's basically saying is that, like a lot of common law judges will do, say that the stuff has been around for a while. It hasn't been very clearly defined, and the constructive trust is the mechanism that equity uses to remedy defects in equity. And while he does think that it is sometimes unhelpful to have this distinction between institutional and remedial, nonetheless, it can be easier for us to understand it that way. It's easier for us to do that, which is why this lecture is split up to only talk about the institutional and not the remedial, notwithstanding the fact that that was what Michinski and Dodds was about. The very last line, though, is important because of the dates. By default, the institutional constructive trusts are usually they arise essentially through the operation of law, and it's that point in time. So these things we were talking about today, things like the knowledge receipt rule and such like, and breaches, they occur and are dated back at the point in time where the particular thing came into existence. This distinction is important because interest rates, and you may or may not be aware of this. I'm going to tell you now if you aren't. Has anyone done civil procedure? Or are doing it at some stage? How was interest calculated under the Act, the UCPR? How is it calculated in the Supreme Court rules? Does anybody know how interest works with judgments? It's a high flat rate. There's no compound interest. So if you get an order from the court, that interest will be added. And as I said, it's quite a high rate. It's, from memory, I think 1.5% higher than the commercial lending rate. Don't quote me on that. But it's a flat rate. Common law, if you get an order, it's at a flat rate. Whereas in equity, you can get compound interest. That is a huge factor in commercial practice that is grossly downplayed in your academic life. Because those two numbers, particularly if you're doing things involving trusts that were set up a long time ago, the difference between those two numbers can be massive. You can get compound interest in equity. And most importantly, if you are backdating this thing to the point in time where it arises, that could be decades ago. Compound interest over a few decades is very nice if you win. And so this rule, and again, with everything in equity, the courts will always intervene to preclude or prevent an injustice. That is the starting point. You backdate things and the interest is compounded. And the types of trust that we're going to do at a later stage, these remedial constructive trusts, like what Justice Dean declared in Michinski and Dodds, they are created by the court. They are created at the moment the order is granted. That difference is huge. Okay. So we're going to delve into this first category, these institutional constructive trusts, in a little bit more. Let's go. I'm going to talk about the types of mechanisms, or the 4 ways that these are going to come about in regards to this particular course. There are some other ones. Some of them, the textbooks don't even talk about, they just allude to them. We're only concerned about these things here. And just make note that the last 2 are usually considered to be the same thing. Or rather, they're talked about in the same cases in the same section of your texts. But the first one is hopefully the most recognizable to you guys. Do you recognize those 2 cases? You probably should do. Because the hospital products case is the case where the High Court went and mapped out the rules for a fact-based fiduciary relationship. Now, you ought to be aware by this stage of the distinction between a status-based fiduciary and a fact-based fiduciary. A status-based fiduciary relationship is one of the named known categories: trustee and beneficiary, employee, employer, company director to company, agent to principal. Those relationships are fixed and they are known, and there are rules that are mapped out in terms of what duties are attached or associated with those and what a breach looks like of those duties. But just make note, and I think I refer to this later on, not all duties in a fiduciary relationship are fiduciary duties. I'll say that a few times. Not all duties that are imposed by you in a status-based fiduciary relationship are actually fiduciary in nature. So for example, a company director. A company director, as for those that have studied company law, have duties like to act in good faith. That's a fiduciary duty. That coexists with the fiduciary relationship that a director has. But company directors also have some other duties to take ordinary commercial risks as part of that process. And in the case, if I put it there, it's Bell Group in liquidation in Westpac. There, the Western Australian Court of Appeal talked about this, and they looked at some of the other powers that company directors have under the Act. The ability or power to allocate shares, for example. And they looked at these and they said, well, some of these are actually not fiduciary. They are part of the director's responsibility to the company, and breaching it may have some consequences, particularly under the Corporations Act in that situation, but not all fiduciary relationships, or not all duties imposed, are going to be fiduciary in nature. And so Chan and Zachariah, again, I'm not sure if Tina talked about this, that was to do with partnerships. And you appreciate that a partnership is where two or more people come together to have or run a business in common for the purpose of making profit. Partnership is a status-based fiduciary, but it's also a contractual relationship. The two coexist quite happily. You can breach contracts with your partners without breaching the fiduciary relationship. Just not repaying the interest on the loan that you had for partnership property, for example. Another one, an important one that, again, was later after the break, is the relationship between agent and principal. Agent, principal, usually that's a contractual relationship as well, but there is, and there are, duties for the agent back to the principal. And some of those are going to be straightforward, not making secret profits, for example. But a lot of these things you guys should be aware of, not making secret profits for agents. But other duties might be merely contractual in nature. They're not going to be a breach of fiduciary duty. And so it's important to note here, again, this is really an exam type situation, that if there are breaches, to just make note of the fact, sometimes they can just be contractual breaches. Sometimes they can just be breaches of the common law obligations that can flow or coexist with the fiduciary relationship. Okay, now, these next three things. These next two categories, two, three, I've done them in a bit of a strange order, because this case Barnes and Addy. I'm not sure, did Tina talk about that case? The two limbs of Barnes and Addy? This idea of assisting a fiduciary to do something dishonest. Assisting a fiduciary to do dishonest things is actually the second limb of Barnes and Addy, not the first. The first one is to do with the receipt of property. And so we call these rules the knowing assistance rule and the knowing receipt rule. So those acronyms, probably just going to have to remember from this point forward, because in your exam, that's all you have to write. It's called the knowing assistant rule and the knowing receipt rule. So you're going to see those acronyms, and in some of the slides going forwards, because I'm going to take a break after this one. And that is what those acronyms stand for. The other one, ICT, is in the heading. I've just made that acronym Institutional Constructive Trust. You might not see that referred to that often in Nicola or Tom's notes or in the texts. It just helps it fit on the page. Okay, so I'm going to talk about each of these, this idea of assisting people to do dishonest things when there is a fiduciary relationship, and the receipt of trust property. And again, that falls into those two categories, into those two bottom ones. There's the receipt of trust property that has been obtained as a result of a breach, has certain rules associated with it. The difference between those two things, those two rules at the bottom, is actually just knowledge, or when the person became knowledgeable of the particular breach. Because knowledge in this area of law matters. And the state of the person's mind matters because these rules flow from conscience. Keeping and holding things and making benefit in situations where it is against good conscience. So I will going to pause it there. We'll take a break for about 10 minutes and then come back. And we'll zoom into those in a bit more depth. I've already talked a little bit about Chan and Zachariah. That was a partnership involving I think they were doctors or dentists that came together, and the issue for the court was whether or not, after the partnership had ceased, whether or not the fiduciary relationships carry on. You guys might have studied this with Tina. Do you know what the answer is? Yes. Yes, they do. So if you're in a business partnership, that's a contractual relationship. When that contractual relationship ceases, the fiduciary relationship lingers. I'm going to turn the volume up as there is. Is that a bit better? Not really, a little bit. I'll stand over here. Keach and Stanford, though, that's sort of the foundational case for when we're starting of this idea of institutional constructive trusts, because the basic or the most common or the most well-known and well-structured category of constructive trust is the institutional ones, and the most well-structured category of those are for breach of fiduciary duties. And so that's the starting point of things, because you guys already know about this stuff. With Tina, you would have talked about breach of confidence, for example. It's a breach of a fiduciary duty. And so Keach and Stanford is a very old case. So Keach, and the plaintiff here, was an infant. He was young. He was younger. He was under the age of majority, which I believe was actually 21 at the time in ye olde England. And he had inherited a lease on a building in London. And Mr. Stanford was the trustee. He was entrusted to look after the property until the child came of age. And before that time, though, the lease expired. So the landlord had said to Mr. Stanford, look, he didn't want the child, the infant, to have the renewed lease. And you guys are probably aware from contract law, what are the types of contracts that can actually be validly held between minors? It's only contracts for the necessities of life and beneficial contracts for service. A lease is neither of those things. And so the landlord didn't want this lease to carry on, did not want it to carry on with the infant. And so Mr. Stanford took it up. So this is an opportunity the infant couldn't take. Nonetheless, when the child grew up, he went and sued Mr. Stanford for the profit that he had been making by having that lease from that point forward. And he was felt liable. Constructive trust arose, and it was backdated to the time of the breach. So the time when the landlord had stopped wanting to deal with the infant, that was the point in time when Stanford picked the lease up. And really the principle that flows from this is that breaches of fiduciary duty are very, very strictly interpreted. You're held incredibly strict to your fiduciary duties. And for the purposes of what we're doing here, the time of that breach is the relevant time for when the constructive trust is going to arise. So again, the profit that was made or interest that flows from that. Both of those from the time of the breach. Now, Attorney General of Hong Kong and Reed. This was something of an interesting case. It involves a prosecutor, a crown prosecutor in Hong Kong. And he took bribes. He took bribes from various criminal elements, and he took those bribes and he spent that money buying residential property in New Zealand. For all of those who have known me for any decent length of time will know that I'm firstly a Kiwi, and secondly that I absolutely abhor the fact that New Zealand has no capital gains tax. As such, if you buy residential property, it can only go up. And that's what happened. So this guy took bribes while he was in Hong Kong. This is a Privy Council case. It's gone to the Privy Council. Hong Kong before 1997 was still part of the British system. New Zealand until 2003, and Australia, you could appeal to the Privy Council up until when? Australia Acts, 1986. The Privy Council was the highest court, essentially, higher than the High Court. Now, these properties went up in value radically, and so there was a problem here, and that the existing rule for these fiduciary breaches, which is based old case, which I can't remember off the top of my head, is that you are to be put back, or to take the money that was made and put it back. You've got to make do on what the wrongdoing that you've done. What's the notion of how these things sat? Because if you did have some money and you committed some sort of breach, that money belonged back to the person who you're taking it from, right? What was the problem here? Well, the problem here was that the money didn't come from the Hong Kong government, it came from criminals. We've got something of a problem here, because earlier I'd mentioned that in our system, we don't really like this system of unjust enrichment. We'd much prefer to base things in Australia from unconscionable conduct. Doing things for the individual is doing something against good conscience. Here we're stuck with something of a problem, though, because the rule is you take the money and you give it back to the person who you took the money from. That's pretty straightforward. But that isn't really how this is going to operate here, because that money never came from the Hong Kong government. And so we've got something of a problem. And so the courts there really had to draw principles from more basic rules of equity. And that is that the person cannot profit from their own wrongs. And so, yes, the Hong Kong government is going to be and receive this benefit, but they weren't the ones doing the wrongdoing. And so in that situation, even though the amount of money was vastly in excess of the amount of money they received, and the amount of money received didn't even come from the Hong Kong government in this situation, it came from third parties. It had to be taken away from them. You fundamentally aren't allowed to benefit from your own wrongdoing in equity. And so it does create something of a problem. It's something of an anomaly. But if you think about it, it's quite an unusual situation as well. And so equity is going to go and trying to fill in the gaps to try and find some result. But the result didn't flow from what we generally do in Australia, which is from good conscience. They had to undo this benefit that a person had received from his bribe. So don't be wrong, he went to jail and had to pay a big fine. This was only to do with the properties in New Zealand. Similarly, I've got Grimaldi, chameleon mining. That involves mining tenements in Western Australia. And there was an agreement, I'll go through the facts, because from time to time these can come up in things like exams. So Murchison Metals is a mining company, and it acquired tenements in a big area called the Iron Jacks. It acquired those, and it acquired those from a company called Winterfall. And they had an agreement with the vendors of Iron Jacks to buy the mining tenements for $1 million in installments and royalties for any ore extracted. And so Winterfall couldn't pay the second installment, so Murchison paid the installment. And Winterfall was allowed to essentially, as a result, they were allowed to do a reverse takeover. And so how this came about for these parties, Grimaldi is a director of Murchison and what they call a de facto director of Chameleon Mining, which is, and the other person involved here is this guy called Barnes, who was also director of Chameleon. They then used the Chameleon's share capital to raise the funds to acquire the tenements. And 5 million shares were issued to Murchison. Murchison's Chameleon shares were then sold by Grimaldi to provide the funds that Murchison had committed to assist the purchase of Iron Jacks. this guy Barnes also drew some checks on Chameleon payable to Iron Jack's vendor. This also contributed towards Murchison's commitment to Winterfall. All right, and so basically the court looked at this and said, well, hang on, this is dishonest. This has been done for Murchison's benefit. They've issued all the share capital for Murchison's benefit, not for Chameleon Mining's benefit, and also for Grimaldi and this guy Barnes' personal gain. And so this reverse takeover of Winterfall occurred. 10 million Murchison shares and 12 million options were also provided to Barnes and Grimaldi as their spotter's fee. This tenement was estimated to be worth $1 billion, and so Chameleon gained no benefit at all. And so here we've got to try and work out whether or not there is a fiduciary relationship, because remember that he was a de facto director who went and did things appearing to be a director. He wasn't listed as a director, and no valid minute had been passed appointed him as such. And so the court there said, you are deemed to be a director, and thus you breach the fiduciary and the statutory Corporations Act duties. All right, and because they'd done with this undisclosed interest in the spotter's fee, and they'd misused their fiduciary positions to divert these funds, it violated the conflict of interest provisions as well as the duty to not make secret profits. So the court said, and this was a split decision as well, because earlier on I'd mentioned that status-based fiduciaries have a collection of duties. Not all of them are fiduciary duties. So you can have duties under the Corporations Act. And this was a split decision, 2-1. Some of those are going to be fiduciary, certainly the ones from 180 to 184 in the Corporations Act. You guys, do you remember the ones I'm talking about here? There's general duties. Louise talks about them a lot. And so there they said, look, they're going to be jointly and severally liable. Have you heard of that phrase before, to be jointly and severably liable? That's a term used by the court when multiple people are held liable in a civil action and you can seek money from any or all of them. I'll repeat that again. Being jointly and severally liable means that you, as a person who's usually the defendant and you've lost, and the other side has a court order that renders you liable to pay, renders all of the parties liable to pay, and you can seek money from any or all of the parties, any numbers of them. Why do the courts do that? Because they want plaintiffs to get paid. So you can go and try to get the money. If you've got a court order, you can try and get the money out of any or all of those parties. Okay, so they were held jointly and severally liable with Barnes's nominee for the spotter's fee in the form of these both Winterfall and Murchison shares. And they received those shares as reward. This was a breach of the fiduciary relationship and occurred without Chameleon's consent. That was the company that they owed the duties to. And Grimaldi was also liable to account for those shares. In other words, the court said, you have to go account for that to undo the particular breach that you've made in that situation. That was, otherwise you would have gained from that particular transaction, and we're not going to let you just get away with repaying the barest minimum. When you've got a fiduciary breach, it's against good conscience for you to just repay the barest minimum and keep the rest. That's really the principle that flows from these things. It's not in good conscience to do that if you end up being unjustly enriched. Okay. The knowing assistance rule. Whatever reason I didn't put it on the slide. It's on the top of the next slide, but this is an institutional constructive trust for assisting fiduciary to a dishonest act. And so and again, the language they use is expressed in broad terms. They use the phrase fraudulent design. And even though it looks like I'm doing this out of order, this is the second limb of Barnes and Addy. Barnes and Addy, they talked about this assisting people, and they also talked about knowingly receiving property. Those are the two aspects of Barnes and Addy. And the High Court in this Farah Constructions and Sadie, they also talked about this in a bit of depth to map out how this area works. And I am just going to go through with a bit of commentary and try to explain some of those things. So this is from paragraph 159. It's a joint majority. I think it was Gleeson. Chief Justice Gleeson was, but I think he was joined by a few of the others, but I haven't got them written down here. I think it was 4 judges. As conventionally understood in Australia, the second limb of Barnes and Addy makes a defendant liable if that defendant assists a trustee or a fiduciary with knowledge of a dishonest and fraudulent design on the part of that trustee or fiduciary. Now, there is a distinction between rendering liable a defendant participating with knowledge in a dishonest and fraudulent design, and distinct from rendering liable a defendant who dishonestly procures or assists in a breach of trust or fiduciary obligation, where the trustee or fiduciary themselves need not have engaged in a dishonest or fraudulent design. Now, there is a distinction, but you can be held liable for either. And let's go. As a matter of ordinary understanding, and as reflected in the criminal law in Australia, a person may have acted honestly, judged by the standards of ordinary decent people, without appreciating that that act in question was dishonest by those standards. So it's against this background it has been customary to analyse the requirement of knowledge for the second limb of Barnes and Addy by reference to these 5 categories below. Those limbs are either actual knowledge, that's the first one, willfully shutting one's eyes to the obvious, 3, willfully and recklessly failing to make such inquiries as an honest and reasonable person would make, 4, having knowledge of circumstances which would indicate the facts to an honest and reasonable person. And 5, the contentious one, having knowledge of circumstances that would put an honest and reasonable person on inquiry. I'll go through those 5 things again. And this is restating an earlier case, a UK case, Baden, B-A-D-E-N. And forgive my French, the Société Générale pour favoriser le développement du commerce et de l'industrie en France. I did apologise. I didn't get any better. But the case citation for that is in 1993, square brackets, volume 1 of the Westminster Law Report, so WLR, page 509. That's an earlier case. It's actually quite old. The citation is from 93, but the case was actually heard in 1983. So 1993 is the case citation. So the case predates, and importantly, it predates all of the Australian cases in the 80s. Okay, so I'll start those 5 again. This is Farah and Sadie Constructions. That's where this list is coming from. It's actual knowledge, or willfully shutting one's eyes to the obvious, or willfully and recklessly failing to make inquiries that an honest and reasonable person would make, or having knowledge of circumstances that would indicate the facts to an honest and reasonable person, and 5, having knowledge of circumstances that would put an honest and reasonable person on inquiry. You guys know what that means by on inquiry? A little alarm bell should go off. You need to go and investigate this. So that, and what the court did, the court refers back to an earlier case, which was console developments in DPC, which I think we probably did with Tina as well, maybe. And so here they talked about console developments, and then they said, look, in console developments, there was support could have been found for the first 3, and then some of the judges reckoned 4 as well. Here, though, the result in console is that console supports the proposition the circumstances falling within any of the first 4 categories in Baden are sufficient to answer the requirement of knowledge for the second limb of Barnes and Addy. That is, this knowing assistance rule, the knowledge that's required. Here the High Court is saying, in this way, it's accommodated through acceptance of the 4th category, the proposition that the morally obtuse cannot escape by failure to recognize an impropriety that would have been apparent to an ordinary person applying such standards. In other words, what they're saying is that 5th category now applies in Australia too. Farrer Constructions and Sadie say that those 5 limbs from Baden now apply. That is the test for knowledge, for knowingly assisting a fiduciary. It should be followed by Australian courts from this point forward. All right. Okay. So just before I move on, this idea of knowingly assisting somebody. The knowledge is the key part. And again, in terms of your assessment, that's going to be the bit that you're going to have to examine. You have to examine whether or not the particular breach is a breach of a fiduciary duty. And you're going to have to know whether the person assisting it had the requisite knowledge. And I said, look, it seems a little unintuitive for this to be the second limb of Barnes and Addy, but it's a little easier to go through, I think, to do this first. So Farrer Constructions is where the High Court talked about that. All right, the KAR in regards. This is for professional trustees. We've got a few more slides actually about this. All right, because there's one slight problem here in terms of trustees and doing things involved with trustees. And this, I've got one on the next slide where it came up, but just make note that trustees actually have different duties of investment than company directors. Company directors take ordinary commercial risks because they're trying to maximize shareholder value. Whereas trustees, in terms of them doing what they do as part of their duty, can only take low risk things. So I think of this, I won't do a little diagram, but for those that have studied accounting economics, that idea that if you have a low risk investment, usually that has a low rate of return. High risk investments need higher rates of return. It's pretty straightforward sort of conceptually. If you're going to get more interest from something, or higher returns, there's a higher likelihood that you're going to lose all your money. That's how that works. The thing is with this intersection between company law and trust law is that trustees can't take higher risk investments, even if it looks like they would have much higher rates of return. And again, if we think of this, the banks themselves have got a variety of duties, fiduciary and non-fiduciary, but they are still companies. They're not trustees, essentially. So they're certainly not bound by any of the things in the Trust Act, but they do have some fiduciary duties in regards to their customers, for example, confidence and confidentiality things. Generally, though, their duties are mapped out by statute. So the Banking Act will actually go through and map out what they can and can't do. And the banks have had a bit of scrutiny recently, so that area is probably going to be in a bit of flux at the moment. But they certainly do in regards to their own customers. They've got fiduciary duties. But it's in terms of their own powers to invest, banks are companies. They need to maximize shareholder return. Does that help? I just make note that there's actually an excuse. So the Trust Act gives a person who's a trustee this ability to go and invest. Oh, I've got a carriage return there somewhere. If the trustee's profession, business employment includes acting as a trustee, they can exercise the care, diligence, and skill a prudent person engaged in that profession, business, or employment would exercise in managing the affairs of that other person. In other words, in a situation where a trustee is having to run a business, their duties are different again because the statute says so. And that means when they're exercising their power of investment, it's a prudent person of that particular profession. So that, if you're a professional trustee, that is the standard of care that you're held to. And that's relevant in terms of breach, because these things arise when company directors are breaching and others are helping them do it. Because appreciate that you can breach your director's duties or your duties as a professional trustee unknowingly. You're taking risks above and beyond what ordinary commercial risks are. You can do that unwillingly, but the known acceptance rule requires this third party, the stranger, to come in and for them to have knowledge in regards to something dishonest in relation to those two things. Wrong slide. Sorry, I put the wrong slide. Okay. All right. So a couple of cases here. One of the things to make note is that you have to actually do something. For the stranger to be found liable under this, they have to actually do something to assist in this dishonest set of circumstances. There has to be a breach of duty, and there has to be something dishonest in relation to the two of those things. Just allowing this breach to occur might not be sufficient in most situations. Just letting people go and do things. Somebody, one of the two, either the person committing the breach or the person assisting with the breach, there has to, or both, has to have some aspect of dishonesty to make this work. And things can be a little complex in terms of who the parties are here. And so Finers and Miro involved a law firm where their client had come to them and said, I need you to sort some transactions for us. I need you to do some transactions. Okay, sure, that's not a problem. Seemed like ordinary, reasonable transactions. And at some stage later, this person then disappears, the client disappears. Some stage later, the law firm finds out that this guy had breached and stolen a whole bunch of money in the United States. And the client then comes back to the law firm, and the law firm says, look, we don't want to carry on doing this anymore. You've got us to do all these transactions, and we've now discovered they're fraudulent. And the client, and you can always spot the really weaselly ones who know the rules, and said, well, that's fine and all, but you're under legal professional privilege. So you can't go and do these things. And because the firm, of course, is worried by this stage, if they're going and carrying on doing these transactions, they're going to be worried that they will fall under the knowing assistance rule. They're going to be worried that what they're doing is going to be involved with a fraudulent or dishonest design. And the court said, though, in this situation, there were a couple of things. Firstly, this is a UK case, so they used the equivalent of what we now have in Queensland in section 96 and 97 of the Trust Act. And they said, first of all, legal professional privilege doesn't apply to fraud, not actual fraud. If you guys, as solicitors, are dealing with a client who's been accused of fraud, that's quite a different and distinct thing than somebody coming into your office and telling you about their fraudulent schemes. Those are two completely different things. One of them is in the criminal sphere. You're defending the person and doing them to the best of your ability because the outside world knows about this fraudulent scheme. But you have duties to the court if somebody comes to you and says there's something fraudulent, to actually deal with that appropriately or accordingly to those rules. You can't carry on doing it. And the equivalent of the UK rules, which is the equivalent to our Queensland ones here, says that you can go to the court and ask, hey, we think that we have breached this. And there was one problem with this, though, because those sections say a trustee can appear to go to the court in order to do those things. And the real difficulty was that this law firm, at this stage, aren't trustees. Why? Because no one had gone to court yet and held them liable under the knowing assistance rule to create a constructive trust to render them as trustees. And they didn't really want that to happen. And so you can see there's something of a problem here because the Act clearly says trustee. And our Act clearly says trustee. And what the court said wisely is that that's not Parliament's intent. Yes, it does use the word trustee, but we are going to bend over backwards to interpret that term to include those who are about to become constructive trustees through a breach. Because the purpose of this Act, of the Trust Act in our case, is to regulate trust and trust law. And the purpose of trust law is to try and resolve injustice. And it would be crazy if we didn't, or we insisted that the trustee had to be declared as such ahead of time. So there's two things to note in terms of this distinction between the knowing assistance rule and the knowing receipt rule. The knowing assistance rule requires knowledge to be proved, whereas the knowing receipt rule can be actual knowledge or constructive knowledge, which I'll get to in a minute. So just make note, this is the sort of thing you have to mention exam-wise. Actual knowledge is required for the knowing assistance rule. And it doesn't require you to get anything out of it. You can assist a fiduciary to do something dishonest. Either you do something dishonest or they do something honest, and you get no benefit from that. And that is different and distinct from express trusts, where there has to be some property. Now, you're probably asking yourself, does that sound a little bit problematic? Why are you a trustee if you didn't receive any property? A variety of other remedies, such as tracing. There may be some other set of circumstances where there may be some other property, or the property never left the person and you are just imposed to have a duty on it. Either of those situations can mean that even though you didn't get any property, you can still be held as a constructive trustee? Because you assisted dishonestly in a design in regards to a breach. Okay, so that's the KAR. You are going to be held liable if you, somewhere in this process, fraudulently or dishonestly assist in a breach of fiduciary duty. That will create an institutional constructive trust at the date in which the conduct creates or causes this thing to arise. Courts will backdate that to that point in time. Okay, so if we think of this here, these two, the assistance rules, the knowing receipt rule and the knowing assistance rule, they're just essentially extensions of the categories of breaches of fiduciary duty that you would have studied in equity, and that I talked about a bit earlier. Okay, and when using the knowing assistance rule, you don't have to have property, but you can be made a trustee of property. There still has to be property somewhere. You have to be a trustee over something, but it may not, legal title may not have moved to you. And this is different and distinct from the knowing receipt rule, the KRR. So you've got the KAR and the KRR. Sorry that those two acronyms can be written very similarly. That is where it's property, as a result of some breach, has ended up in the hands of a person, a stranger. Normally strangers, you don't usually hold them to be trustees. It's a very high bar. You don't usually hold people to be trustees, at least not readily. And this can either require actual or constructive knowledge that that particular property flowed from a breach. And again, while you do have constructive knowledge of this, it's this idea that in Australia anyway, we're it's a court of conscience, and we're doing this as a result of this doctrine or this component of equity in terms of unconscionably receiving some form of benefit. And so the knowledge requirement is wider as a result. I'm going to deem you in that situation to be liable. Okay. And all right. Okay. So here, these are the rules for the KR. This is mapped out. I think it was actually in the Bell group. This is mapped out. Okay. For a third party or a stranger to become a constructive trustee, in other words, for this institutional constructive trust to arise under the knowing receipt rule, KRR, you've got to demonstrate all 4 of these elements. Okay, so we have to demonstrate here that first of all, we've got the trust, and here this is dealing specifically with trust property. And so you've got to prove that there is a trust property, either express trust or a constructive trust. There has to be a trust in order for you to misuse trust property. Kind of makes sense. So we're going to be rendering somebody to be a constructive trustee in situations where they've knowingly received trust property under this rule. So the first thing you have to prove is that a trust did exist. And look, that can mean you've got to prove that a trust or operation of law exists. A resulting trust, for example, or a constructive trust under one of the remedial categories we're going to talk about next week. So you may have to go prove that a constructive or a resulting or an express trust exists as the first step. It's kind of logical, really. There has to be a trust situation for a third party to be deemed to be a constructive trustee. Okay, The second thing you've got to prove is that they have misapplied that property. In other words, they've committed some sort of breach in regards to that. Right? But it, strictly speaking, doesn't need to be dishonest. It's just misapplied. It's a lower standard. So you, as the plaintiff, to try and get a third party roped into this, and guys, this happens in situations where you're trying to get the person who has money. All of these situations is trying to find the appropriate defendant, trying to rope someone in and make them a constructive trustee, particularly in a situation where the trust property's all gone. If somebody is a constructive trustee and the trust property's all gone, you're still going to be able to get money from them. They're a constructive trustee. They're in breach of their fiduciary duty. That is why we are using this rule, and that's certainly something that you will be examined on. Why we are doing this is to try and get money out of a third party, a situation where the trust property is gone. So the third party has money, we're trying to get it out of them. Okay, you've got to prove that they did actually receive the trust property. There has to be, they talk about the beneficial receipt. In other words, that they have to have substantially had to transfer to them beneficial ownership of that particular property. So just an administrative one, changing the name on it, but not changing the way the trust actually worked. You don't need to use the knowing receipt rule. If they've changed the name to make themselves trustees, they're just trustees under an express trust anyway. Does that make sense? If you've changed the name, there's some administrative function in regards to that. And you've got to prove knowledge. But going back to fire and safety construction, that goes through and talks about all of these ways that you can go about proving knowledge. And in the case of the knowing receipt rule, constructive knowledge is fine. So it's whether they knew or, and again, under those 5 limbs, or if other circumstances tended to prove that. A reasonable person looking in would think that this person knew or ought to have known that there was this particular property was going to be acquired as a result of a breach of trust. That is the requirements that you need to do. You need to analyze that in relation to a particular situation where there is a third party who somehow received trust property in circumstances, usually for you as lawyers, circumstances as such that you want to try and get a remedy from them. Usually that's because the rest of the trust property is gone. You want to try and get a remedy, a personal remedy, by essentially putting them in as trustees, because trustees have those duties that you can then go and use to the court in order to seek a simple result. Okay. All right, last slide. And last slide is just to do with companies. It's for both of the rules, because the rules in terms of knowledge for corporations, we start with this idea of the directing mind and will. That is the knowledge that we're going to look at in terms of knowingly either receiving or property or knowingly assisting. Okay, and so that they do with these things, when trying to determine whether the company has knowledge, they have to look at the actual people involved in the process. It's a factual matrix. Go through, look at what each of the people were doing, look and see at the evidence about what they were doing in regards to their conduct, in regards to this potential breach or potential dishonesty or potential receipt of property. Yeah, you can look. It's not strictly required, but they can go through and look at the way the rules, the constitution of the company, the rules of the association are set out, just in terms of who in that corporation or that corporate association is the person who's supposed to be responsible. Because we appreciate the knowing receipt rule, it's actual or constructive knowledge is required, either or is fine. Knowing assistance has to have some aspect of actual knowledge, but with a corporation, it all has to be constructed because a corporation's not a natural person. So we have to look at what the natural people did and see if we can impute that back on the company itself. And that final note there is the courts take a pragmatic view. They accept that large entities are complex things. Smaller entities are less complex, and you can look at the individuals involved. That's really what they're meaning there. Big entities are more, it's trickier to impute intent, or at least you have to do it across multiple persons and a variety of sources of evidence. Okay, everybody's heads are probably mush after that. So we will be going over this stuff during shoots. Just make note that next week the test is going to be held in here. So if you've already done the test, you're welcome to come and do the test again if you want to. You won't get a better mark. You're welcome to. But otherwise, I'll see you guys in shoots.